that works. So you work through your motions, and then what are these trials typically about? How do they get resolved?
So it depends on what the landlord has to prove. In a non-pay, it's that the landlord needs to prove that they are the landlord, that this person resides in the apartment, and that they haven't paid this amount of money. If it's a holdover, they have to prove again, I am the landlord, this person is in the apartment without my permission, or they're doing something and I want them to leave. And then at trial, they just have to prove those facts. And that's one of the reasons trial is difficult for us as tenant advocates is it's really easy to prove you're the landlord. We can get into some intricate stuff like you submitted this deed and try to go through the business records exception. But really, if the landlord can prove that they're the landlord and that they don't want this person there, that's it. And then we lose the case. They get a order of eviction or a warrant of eviction. They post the marshal's notice, and then 14 days later, the sheriff can execute the eviction. And all we can do then is do orders to show cause to try to delay it.
So what would be orders to show cause? Like what would the arguments in those orders to show cause be?
I mean, the trial decision comes down. Somebody has to move out by June, the end of June, right? They're looking for housing. They're finally able to secure housing, but it's not until July 15th or August 1st. They come to court. They say, "Here, look, I have a lease, for this new property. I can move. However, I need a little bit more time to allow me to move with dignity." Mm-hmm. That's one of the most common ones that are granted, at least.
Yeah, good cause is it, and there's a whole bunch of reasons why, but I'd like to take a step back in terms of the trial and what the landlord has to prove. The most litigious cases at trial are the ones where we have substantive defenses, and I want to let the people know about what the defenses exist for tenants, right? One of the most potent defenses is de facto rent stabilization, right? De facto rent stabilization, as I mentioned earlier, there are rent stabilization laws in New York State. If there's a building that has 6 or more units that was built before 1974, and now case law has shown it doesn't even need to be built before 1974. If you have 6 or more units, you are subject to the rent stabilization law. There's a nuance point. It's not just about 6 units, but if you have 6 single room occupancies, meaning, and this is very prevalent in Queens amongst these houses, right? What people do is they'll rent out rooms. So if you have 6 rooms rented out, and we find that out, I'm constantly looking for that as a tenant attorney. Well, how many people are living here? Is there 6 people living here? Are they paying rent separately? Do they have separate rooms? Do they have separate keys? That's a potential defense that can vitiate a holdover proceeding, saying that you don't have a lease. Because if it is de facto rent stabilized, then you are entitled to a lease renewal. Right? So they should have never even brought a holdover to begin with. It should have been, assuming rent is owed, a non-payment. So that's one defense, right? De facto rent stabilization. Another defense is retaliatory eviction. Now, let's say in a holdover where you don't have a lease and your landlord sues you because you don't have a lease and they want you out. If you filed a complaint before they issued you a predicate notice, the 30 or 60, 90-day notice of eviction, right? To 311, to the landlord, if you filed a complaint about conditions, you can say that this was retaliatory, and it's a rebuttable presumption saying that the court assumes that it's true, and now it's the landlord's burden to show that this wasn't done because you filed the complaint, but for some other reason. And that's something that you would litigate at trial, right? So in addition to the de facto rent stabilization and retaliation, there's also, am I missing this one? There's several more, but those are 2 important ones that I would take into account, and that would extend the time frame of litigation, right? The same way in a non-payment, you can raise the warranty of habitability, and that would be litigated in the trial part. So we're going through evidentiary proceedings, we're doing direct, we're doing cross. in those instances where we have defenses. And the litigious ones are ones where we have those defenses. Otherwise, if it's, like you mentioned, if there's no defense, it's, are you the owner and do they have a lease? Are you the owner, or if they didn't pay? So it's good to know there are defenses out there that do exist, and tenants are entitled to raise those defenses and speak to counsel about it and preserve those defenses when they file their answers once they get the first petition and the notice of petition, because you have to respond to it. And if you can't file a motion, you can write your answer in, and you could be like, well, they didn't make repairs, or I believe there's 6 or more people living here. The thing is, tenants don't know that they have the right to potentially rent stabilization if there's 6 or more people living in the
And it
unit.
has to be preserved in your answer, or
If
you're
it's-
fucked?
Basically,
Yeah.
at trial, you can make a motion to amend the answer at that juncture, but what tenant knows that they can make a motion to amend the answer?
I mean, I would imagine if you somehow make it to the trial part and you still haven't given a counsel, you don't know what the fuck you're doing. And does that happen a lot? Like, what percentage of people are at that stage with no attorney?
So I feel, and what I see in housing court is that people who do not have an attorney essentially get bullied by the landlord's attorney into agreeing into a stipulation that they don't have to, and they really don't understand just because they don't have an attorney. And I see the landlord's attorneys straight up lie to them and say like, hey, if this was my case, I would just want this out of the court system because I know wouldn't have any defenses. And that's what I'm telling you as a lawyer. Like, I've heard them say that to tenants.
Damn, that's fucked up.
Yeah.
And one big,
You need to do a sting operation. Get those motherfuckers disbarred.
and that's the thing, is that like that's about 90% to answer your question. That's about 90% of the tenants that are present, right? That don't know this and are going through this process and making these agreements.
90% of the population in housing court don't have counsel?
No, not that they don't have counsel, is that amongst the ones that don't have counsel,
Oh, okay. That's
yes, amongst the ones that don't have counsel, right?
They
They get bullied into making these agreements because they don't know their rights.
I mean, I think, that leads us to having to discuss how the resolution part is conducted. It's a total mess. At least in Queens, you have, 4 resolution parts. They could have between 40 and, 70 cases on the calendar for a particular day.
Just to take a step back so I can visualize it. There's a trial part, there's a resolution part after trial, before
Result
before
was
trial.
first.
Huh?
That's the first part. Pre-trial practice is happening in the resolution part.
And to help you further visualize this, every day in Brooklyn, there's a line like blocks long of people trying to get into housing court. And in
Okay.
Queens, there'll be like, I don't know, 50 to 100 people in housing court every
hallways.
day.
Yeah.
And the hallways are just filled with people. It's landlord attorneys yelling at tenants.
Yeah, I mean,
And-
I was there in Manhattan. I can tell this it was
Yeah.
wild. But so the resolution part, is that also the same part that you were talking about in the beginning, where you can file motions? And
Yes.
Stuff like
Yes.
that? Oh, okay,
Yeah.
all right.
So that's got 40, 60 cases in one room, 40 to 60 cases in another room. Those are both conferenced in one room together. So you have all the litigants and the few attorneys. Most of the landlords have attorneys. A lot of the tenants do not, and they're on the court calendar for 9:30, 10:30. But you have all these cases to deal with. So basically, the landlord's attorneys are just calling out people's names. If they have an attorney, they hold off sometimes. They're supposed to speak with that tenant's attorney. Otherwise, they try to strike up a deal with the tenant without the involvement of the court. They're supposed to tell them, I'm not your attorney, I'm the landlord's attorney, I can't advise you. Doesn't always happen. So a lot of the time, deals get entered into, there's an agreement that's signed and then just submitted to the judge's court attorney who sits in the resolution part. So these tenants sign away their rights without even speaking to a judge.
That's fucking scary.
There is the back end where once they sign these agreements, they go in front of the judge to allocute. It's called an allocution, and the
Yeah.
judges are then required to let the tenants know, like, do you understand that if you sign this agreement, you're foregoing your rights to trial and so on and so forth. But the thing is, they don't really understand the degree of the rights that they're forfeiting anyway, right? And then a lot of the times these landlord attorneys posture as decent people who are trying to help you out. It's like a good cop, bad cop situation. You're in a bad situation. You need help. A landlord's attorney comes and presents, oh, you need time? I can give you time. How much time you need? I need 3 months. Okay, cool. They sign up and says, okay, so judgment of possession, right? Warrant issued forthwith. They don't have to issue a 14-day notice, and you owe X amount of money. And they think they got a deal because they got 3 months. But you put us on the case and we file a motion, you'll get more than that, right? And the first day is particularly retained to getting counsel. So some people will come in and you'll have pretty zealous landlord attorneys try to get you to agree on that first court date to a settlement, because that's what they're used to before we came into the picture. They're mad that we're here now, right? But we're here to stay and we're going to keep on fighting, right? One thing I want to say also, because we were talking about the trial part, another defense for non-payment specifically is not having a lease, right? And alternatively, not having a valid certificate of occupancy, which is very important to know. Under the certificate of occupancy is required for multiple dwellings where you have, backtracked. Certificate of occupancy is required for all buildings in the city that were built, I think, after 1920 something. I forget the specific year. But without a certificate of occupancy, you cannot proceed with a non-payment. Basically, you don't owe rent for the time frame that you didn't have a certificate of occupancy. So to all the people watching, go to whoownswhat.org, type in your address, right? Go to the Department of Buildings link, click where it says view certificate of occupancy to see whether or not the premises has a valid certificate of occupancy.
Yeah, I mean, let's stay on the topic of who owns what. That's a fantastic resource for tenants and tenants attorneys. You put in your address, pulls up DOB records, it pulls up HPD records, so you can see violations that have been issued. You get access to so much information that is really, really, invaluable.
Yeah, and in addition to that, I mentioned multiple dwelling because I generally conflate the two, but these are two separate things. Certificate of occupancy is one thing that can prevent your landlord from proceeding with a non-payment. Alternatively, under the multiple dwelling law, if you have a building that has more than 2 units, it's supposed to be registered with HPD, Housing Preservation and Development of New York City. If it's not registered, then they cannot also get the rent that's owed on the apartment. So those are 2 ways that you can potentially not owe any rental arrears: not having a valid certificate of occupancy, and not a landlord not properly registering their apartment if it's a multiple dwelling.
And with C of O issues also, it's important to note there's a lot of basement apartments that are illegal that there's not a proper certificate of occupancy for. So there's a number of issues with that.
Yeah.
Now, play devil's advocate, and what I mean devil's advocate to see if there's a huge scam in lying in here. If let's say for example, I get into housing court for habitability issues, the arrears, and what's the one that's in housing court? What's that?
Use and occupancy.
Use and occupancy.
Yeah.
Is that negated by?
Yes.
That is negated by.
No certificate of occupancy, no registration, no use and occupancy, no rent.
So, like I said, I'm not saying you do this, guys. I'm just, my mind is churning. If I know that my current residence, right, doesn't have something that negates my need to owe them rent, and I get this case into a 16-month housing court situation, right? Because you gotta think about it. Like, you guys are saying, hey, if you know this is true, don't pay your rent and put your landlord on.
We didn't say that. We didn't say don't pay your rent. Let's be very clear. We're saying that if a landlord sues you for non-payment in housing court and they don't have a valid certificate of occupancy, then that's a defense to the use and occupancy and the arrears that you owe.
Yes, exactly.
That's what I'm saying.
Yes.
Right? And I'm anticipating your question. And one of the defenses to that, a counter to that, is if you moved into a premises knowing that there was no valid certificate of occupancy,
Okay.
then you are barred from raising that defense.
Okay,
If
so-
you knew.
If you know. Okay,
If
that's
you
what I'm saying.
did not know and you magically stopped paying rent because you couldn't afford the rent, that does not preclude you from that defense.
Okay, yeah, because
Does that make-
it seems like I would purposely rent an apartment that doesn't have that, then get myself into housing court, in which I'm supposed to be saving all these use payments, months and months of use payments, and then at the end of it, sit there and go, oh, Trump card, I never had to pay this, and I would have to pay it, right? In theory.
If you didn't owe, if you owe the money and you didn't know about that C of O, certificate of occupancy, or the registration, that is a defense and it bars them from collecting payment. And obviously there's always different facts and nuances, but that is the general law.
Important to note, it's not collectible in housing court.
Okay. Oh, so what does that mean?
So, there's numerous circumstances where a landlord could take you to small claims court for money owed. However, the distinction there is they cannot get a warrant of eviction. So, there's cases where, money will be either, waived or severed for a plenary action, so it gives the landlord the opportunity to still seek that money from that person. They just can't evict over that amount.